All right, everybody ready to go? So today is our last talk. I have really tried, probably not succeeded, but really tried. I've gone through every slide in the course and tried to get to a place where we might have some tentative conclusions and some take-home value that speaks to all of the course. There are a lot of slides. I will go through them quickly. Many of them you will have seen in one form or another, although likely modified today. And there's a fair number that you haven't seen before. So let's see how we do. First on Project Oculus, thanks to everybody who participated and everybody who was in this classroom and participated in that way. There were some wonderful, thoughtful posts, the bottom line of which is I think we're all a bit surprised that there are likely some very legitimate pedagogic uses, especially, I think, for distance education. It actually feels like all distance ed should be done in a real immersive environment, and I'm a bit of a critic of distance ed. I think it's great to put courses up on the website, but I think it's important to have a real class and a real classroom. But maybe through Oculus and other 3D immersive techniques, if we can figure out the feedback loops, something good can happen. There's also Jesse Judry sent me a really nice video, which is 1.5 minutes long, which is on the website, well worth watching, especially for those who didn't have a Rift. You'll get a bit of a feel for what it was like if you did have one. Perfect, you know, last class still doesn't work. Okay, Wiki, gonna work on this. Just a reminder that you can rewrite the entire book over the summer or next semester if you want to. And we'll also do a post if you choose to post your paper to the Wiki as to how you do that. So I'm trying to have a meeting this Friday and get something up shortly thereafter. For those of you who are on badges, we've put up a survey. The Open Badges group has put up a survey. What you may find most interesting about the survey is that EA has put up 2 games, which will be individually drawn among those who completed the survey by the 12th of December. So if you look at it, the odds are really good. And the games are NHL 15 or FIFA 15 or any other game that EA has and on any platform that they make it in. So a ton of flexibility. We should be able to get you the game you want if you win one of the 2 draws. And the odds are pretty amazing if you think about it. Okay, so we're at the end. We really are. And last week was the introduction to the end, and today is the end of the end. There is nothing more practical than a good theory, and the question is post-structuralism a good theory to apply to games and therefore to video game law? So where were we? We were talking about chill last week. And you can think of chill in the creative sense probably most easily by thinking about defamation law, by thinking of media contempt, and prior restraints of various kinds on freedom of speech. Now widen that out to expression, to creative expression, to creativity generally, and you move towards gaming. Because I'll bet it was a little difficult at the beginning of this course, hopefully not now, to conceive that when you were moving your joystick or on your controller or on your steering wheel, that that's a form of creativity. But if it is, then chilling you out from that, restraining you from that, should be a legal problem. And we've seen in the context of mods in various ways, and last week. All right, starting over. So today, we're doing the last part. There is nothing more practical than a good theory. Is post-structuralism a good theory? And if it is, how do we apply it to video game law? Last week we were talking about prior restraints in the context of mods. And when we're talking about mods, we're really talking about the right to create. And recall that that right to create is a different right than a copyright, because copyright tends towards being a property right in the creation as opposed to a right that is part of the creative act and fully tied to it. That's a fine distinction, and we've debated it at various times, and it will come back in the context of the class today. So when we're talking about prior restraints, when we're talking about chill, last week we looked at the Blizzard case and the Schwarzenegger case, which you had heard before in that context. And the common denominator of both of those cases, which are both prior restraint cases, is that when you look at them closely, you understand that what the courts were concerned about was creativity. A lot harder to see that in the Blizzard case because it comes up in a very narrow way, a very tricky way, where counsel for Blizzard says, this case, which is about modders tinkering with a delivery system and a game matching system, is not about creativity. So the extent to which that case focuses on creativity is about trying to push it off to the side. And of course, in Blizzard, the modders lost. The salve is only that the case is distinguishable because it was argued, though that mod was argued to not be a creative act. In the Schwarzenegger case, creativity is much more directly faced, but still in a somewhat limited way by the U.S. Supreme Court in the context of the creator of the game, the producer of the game. The U.S. Supreme Court does not see, nor should we expect them to see, that the players of the game are engaging in a creative act. And probably until you came into this course, you would not have contemplated such a result either. So when we look at creative chill, it's easier to see intellectual property law as a prior restraint to creativity. That's fairly well-traveled as a path. And I would invite you to now look at contracts and end-user license agreements and terms of service as even greater prior restraints. The question is, what do we do about those, and how can we do something about it? You know, if you think of freedom of expression in the Canadian context as a charter right, and you start applying it, you know the limits of, you've all taken first-year constitutional law, so you know the limits. It can affect, the charter right can affect the law of contract, but it can't affect the contracts between two parties. So this slide is a little bit messed up. Today we're going to talk about breaking through creative chill in hardware and elsewhere. So you've seen this slide before. No, you've not seen this slide before. This is a new slide. This is a really interesting issue. And it arises out of my gaming interest, which you know to be racing games. And why are there so few wheels available for the major consoles? Racing wheels available, racing peripherals available. And this is an old issue because I remember a number of years ago there was a peripheral maker in Richmond, and I was talking to him. He made a non-force feedback wheel, which was the best in the world at the time. And then force feedback became the rage because Logitech was making force feedback wheels. And I asked him if he was going to make a force feedback wheel, and he said he couldn't because they wouldn't license it to him on terms that could be remotely financially acceptable to him. So immediately, as a lawyer, you start thinking competition law, antitrust principles, and you forget as a lawyer how expensive and impractical cases like that are, how large they are. By the time he moved through all the obstacles, he probably was going to be out of business because I sort of quizzed him about it. Please, Ryan.
Sorry, who wouldn't license it?
Wouldn't. Who
wouldn't license it?
He said that the holder of the patent on force feedback would license it, but on terms that were completely financially impractical. And it becomes very difficult to prove that that's an intentional thing, that they are effectively bestowing a monopoly on one or two parties. So these are very, very difficult issues. Now, the current iteration is a question. So what's the deal with steering wheels for the PS4 and the Xbox One? Why do we have so few of them? And this is from that article, What's Going On? We don't have full answers. At a base level, peripherals for both the PS4 and the Xbox One must have an onboard security chip. And to get through that chip, the practical way is to get through the mechanics of that. In reality, you need a licensing agreement with Sony or Microsoft. And that seems to be an obstacle to entry. Seems to be. Again, there's less about this that we know. than we probably want to know. But that principle of looking at where there's exclusions from platforms, is a very interesting issue and a big legal issue, perhaps moving forward. Where we see the issue joined, the platform issue joined in a very overt way, is the issue of net neutrality. You can say to yourself, what does this have to do with steering wheels? But if you look deeply, it's essentially a form of the same issue. Do you have access? Do you have access on fair terms? This is classic competition law. We have the issue in Canada. There's various forms in the States. Some people believe this is a huge gaming issue. I would commend in particular this Kotaku article, which goes through all the ways that net neutrality can affect video gaming. And it's also a pretty big social issue. Because if you look at access to the net, access to video games, and you look at it across socioeconomic classes, and you create huge distinctions between the privileges to game, or the net privileges, what other people are going to think of, but we're going to think about it in a gaming context, where rich people will game better because they have better connections than poor people do. Now, I'm not sure who that's going to keep up at night, but if you think about it in a broader entertainment context, maybe it should keep us up at night. And if you think about it in terms of how important games are to kids and how huge multiplayer is, maybe this is a social issue we're not seeing clearly. Anyways, more research needs to be done, and we need to be realistic that sometimes the gatekeepers win. But it looks like, at least the United States and the President of the United States is clear that the internet should be a utility, and the internet being a platform is absolutely key to video games. So, this is out of the wiki for the first edition of the book. I hate to quote myself, it's the only time you'll find me doing it. Technology choices are capable of becoming the ultimate bottleneck to creativity. The case to think about is Sega and Accolade. It was a really interesting early 90s case. U.S. Court of Appeal. Accolade was a games maker, a creator, did not want to pay the license fees to be on Sega Genesis, reverse engineered the Sega Genesis system so that it could make games for the Sega Genesis and market them, did not use Sega logos, went as far as it could to not breach trademark, et cetera, et cetera. Probably the best known game was Mike Vitka Power Football, but there were 5 games at issue. And the court said, yeah, that's okay, Accolade. It's your objective was to create games, and you can hardly create games if they don't have a platform to be on. That's the steering wheel issue. It's also the net neutrality issue. What has intervened? Some extent in the United States, it's the Digital Millennium Copyright Act and the non-circumvention provisions. And we have some equivalency to that in Canada. So there's a nervousness. If you're circumventing a technological measure that controls access to a work, now that's an interesting word, then you can't do that, except unless you can find some exceptions. So right away, if you're going to try and apply the principle in Sega versus Accolade, you're running to your lawyer to figure it out. Now, a second interesting principle that I wonder if any of you thought about this when the case came out. So 2 weeks ago, the Supreme Court of Canada, to considerable fanfare, so I'd be surprised if you haven't heard about this case at all, released a decision that made it clear that good faith was a requirement of contractual performance, and parties have to act honestly in the performance of their contractual obligations. No one really knows what this means, but we do know from the words of the court, and they quote an American statute, the obligations of good faith, diligence, reasonableness, and care may not be disclaimed by agreement. You can't contract out of good faith, diligence, reasonableness, and care. So I invite you, in the context of this course, to apply that principle to end-user license agreements, terms of service, privacy agreements, in-game purchases, modding, exclusions from mods, exclusions from reverse engineering, et cetera, et cetera, et cetera, et cetera. Exclusion from platforms. We have no idea what this principle is going to mean, but think about what it could mean to everyone who's never read the contracts that they've agreed to. Is that a factor? Can a court look at that and say, you, Mr. Distributor, or Mr. Developer, you know no one's reading your end-user license agreement, and I'm going to read good faith in that context. This can go very far, or it can go not far at all. And that's remaining to be seen. For our purposes, the freeing that can come from that is potentially important. Every freeing is important. That's kind of going to be the pith and substance of what I'm going to conclude with today, because every constraint that we put on creativity, and there are a lot of them, is just that, a constraint on creativity, and likely something we don't want to have. And something that goes against, and we've talked about this earlier in the course, a trajectory of liberalization and democratization that we've generally had in Western thought. So think of freedom of expression in that context. Think of the freedom to create, the freedom to mod in that context. So is it really that simple? Is creativity the answer to all of our questions and all our conundrums in this course? Not necessarily in the wider world, but just in this course. So let's examine that. We can go through this quickly. The original puzzle. Why are we addicted to games? Why do we watch them? Why do we play them? Well, maybe we're just magnetized by the creativity that games provide. I put it in a sporting context because I think that's mostly what my cousin was talking about. But it's always good to get right back to the basics. Go back to Areopagitica, John Milton, and read it, and you will see it's about trusting the creativity of the people. That's what he keeps saying over and over and over again. Trust the people of England to express themselves, trust their expression, trust what they create, and honor that. That's the basic freedom of speech principle. So you remember this? Shiokaku, the process of creating a model of the world using multiple feedback loops and various parameters in order to accomplish a goal. That is the definition of consciousness. That's also the definition of you as a creative being. Jung, again, the invention of good games is about being in touch with your instinctive self. Invention, creativity. Evolution is creative. And even this piece that we talked about, where people are motivated to play video games because they allow us to sample our ideal self characteristics, can be seen in the context of self-creation, because that's quite literally what it is. McLuhan takes us to social creation, and Boyden makes all of us, in a game context, the creator of meaning, which is probably the most profound of all of these. We create our own culture, and ultimately, it's post-structuralism that gives this notion real play, pardon the pun, it's intentional, and real expression. You as author. We've gone through all of these. I won't bore you with them again. I've got some additional material which I will bore you with. What this means is that authorial intent is not the primary goal of a textual or narrative analysis of a work. The author is decentralized, replaced with the reader. In a gaming context, the developer is replaced with the gamer. Those themselves, I'll point out, are creative acts. When you look at a game, at a video game, and those of us who play games, I think, really understand this. It is not about what the developer intended. It's about what we do. And it's sometimes very surprising. And EVE Online is a great example of where it can be very surprising. So, if you've not rejected all that as bunk, what are the legal implications? So I'm going to invite you. This is a slide you may have seen, but it's worth focusing on before we end this off. It's a quote that I saw last summer. We cannot know how we would have acted, but we now know how we should have. And it's a very serious quote, but without hopefully sounding too maudlin. Creativity, human creativity, is not something that should be trifled with. It is a serious matter. So, what we need to identify legal principles is a solid ethical model. Post-structuralism is the nominee. And there's a really striking possibility here. And that is that the post-structuralist view of the world and the humanly creative view of the world are actually the same. I'm going to ask you to hold that thought. But I think we have a post on the website that pretty well says that and proves it. And I'll invite you to reread Jane McGonigal, Post-Structuralism and Speedruns. That's my interpretation of it. And if they are the same, if post-structuralism and human creativity are the same, then that's really key. And this is not my strength, so you'll have to forgive me if this formulation lacks some logic. I don't think it's tautological, but it may need a bit more. If you want to have laws relating to games or any creative art, they must be congruent with and supportive of creativity and or a post-structuralist modality. That's the test I am going to suggest to you. And so now we're going to apply that test. And there's, I never showed you a picture of Jacques Derrida. He has amazing hair. And you have seen this, word alignments. I've added 2 more words, creative and chill. And you see exactly where they go. And you've also seen what the list really means. And on one side of the ledger, you have the human and the creative. And on the other side of the ledger, you have the constraints and the platform. Because the platform forms the constraint. And remember, you know, this came up, I think, most poignantly a couple of weeks ago when we were talking about cheating in games, and when our guest made exactly this point. So, a couple of things. It's not enough to deconstruct and expose the way oppositions work. I had not seen that quote when I did these slides way back when. I just discovered this quote more recently. So, fascinating, that I kept identifying the oppositions. Derrida would say, that's good that you did that. It's not enough to have done that. Deconstruction needs to create new concepts, not to synthesize the terms in opposition, but to mark their difference and eternal interplay. Okay, so that's either gobbledygook or good philosophy, and it probably is. If you're going to deconstruct, you have to create some new concepts, you have to create some new laws for our purpose. But I also want to invite you to look at this like a Disney movie. There's one level more. And that is, one more time, this line reinforces how video games fit so well with deconstructionism or post-constructionism. Because think of when you play a game. You create new things, new feelings within yourself. You use the various concepts, the various oppositions that the game gives you, and you create something new with it. So that I found quite striking, and reinforce that with all the different concepts in gaming that seem to be post-structuralist. And now let's apply them. And apply them to 5 things. These are just my views. This is obviously a first attempt. So this is the great conundrum. I always presented this slide for the past probably 3 versions of this class, including this one, as kind of an Escher drawing. Couldn't solve it. What do you do about tattoos? Well, if you look at tattoos from a post-constructionist perspective, it's actually easy. It's really easy. They're different authors who are doing different things. There's the tattooist. There's the subject. There may even be the person playing the individual who has the tattoo in the UFC fighting game, or watching it on television, or deriving some further creative act or mod from it. So if you look at it from that perspective and you apply it, then we have the other example. The Rod Stewart is being sued over the rights to an image of his own head problem, which I brought up earlier in the course. It's just a derivative of the same issue. Then it's fairly easy. The original author does not, should not have a right to compensation in our, if we're saying we're going to use post-constructionism to derive legal principles, but, and there's a wonderful but here, moral rights. You know, if you write a song that's about, let's say you're on the left side of the political spectrum, and you write a song that is about whatever, but has to do with your political beliefs, and it gets used by an ultra-right-wing candidate for political office without your permission, perhaps you should have a right to object. perhaps the tattooist's argument is not, that's my property, I should be compensated. Perhaps it's, I'm aghast that my tattoo would show up in a video game, a violent video game that encourages children to do violent things. I object to that. That's not why I got into the tattoo business. That's not why I do tattoo art. Very, very subjective. And very, very subjective is very, very post-structuralist. So it fits. So moral rights, a lot of people don't like moral rights. Fits very well into post-structuralism. And this was the debate that Ryan and I had earlier in the course. This is my reformulation of what I should have said in that earlier slide, which I showed the following week. It's the only legal concept which directly incorporates the process of creativity. So it really is aligned. Right to create, obviously, we've talked about so much in the course, not going to spend a lot of time on it, aligns very well with post-structuralism. Copyright law, as it stands, does not. Why? Because it tries to insist on authorship and limited authorship, and tightly defines that in a pretty structuralist way. Privacy, this is interesting to me, hopefully to you. Privacy has some post-structuralist elements because the traditional, where we've come to on privacy is the notion of reasonable expectation of privacy. So if you look at privacy law closely, it's about even the British Columbia statute. It has the notion of what your subjective expectation of privacy is, at least some notion of that. What I'm saying is it can become even more that way, and in the Gamergate controversy, we see the reasons why it needs to become more that way. Because when you get through all the rhetoric, what you actually see is that the Gamergaters are very, very structuralist. They go to very literal definitions of freedom of expression and freedom of their own expression. And they're quite intolerant, I think it's fair for me to say, of other people's expression and, certainly some of them, other people's privacy. Now, a slightly less controversial note, but still very controversial, apply a post-constructionist interpretation to the right to be forgotten. A lot of people don't like the right to be forgotten, but it holds up pretty well. It's very subjective. It's very much about the individual. No 2 points, no 2 snowflakes will look alike. Now, you can say that's a bad thing. And certainly from a legal structural standpoint, it appears to be a bad thing. But in a real way, it's probably a good thing. Requires more effort, requires more analysis. And here's where a post-structuralist interpretation of privacy is completely necessary, because none of us will ever fully know the ways of our own brain. And we know our brains are completely individual. Whatever we do with freedom of thought in a virtual reality, brain gain world is terribly important. And if we simply try and do it in a structuralist way, we will fail. All of these things line up fairly well. Moral rights, right to be forgotten, freedom of thought. And now we come to contracts. A fifth issue. This you have seen before. Nintendo bricks Wii U consoles unless owners agree to new EULA. There's your starting point. Real question, do we even need them? And the point. End user license agreements as currently constructed. And what I mean by that are where everyone knows that no one is reading them, are about as constructionist and structuralist as you can make anything. They're rigid, unforgiving, and one document applies to millions of people who have not read it. Doesn't get more structuralist than that. So, some final thoughts on a variety of issues in the course. So, talked about kind of the arrow of time in various places of the course in terms of the democratization of thought. Where that seems to be going in copyright law, again, thanks to the Supreme Court of Canada, is user rights. In contract law, it seems pretty clear we're going to have more and more consumer protection interventions. Think of what Jaz Purewal was telling us. And privacy is very much in play and very much uncertain and very much a power struggle right now. But I'd like to hope for freedom of thought, freedom from surveillance, and no implied consents, express consent. That said, whatever we may hope for, law is slow. Even if you're right, law is slow. But it all works out in the end. And it works out in the end because our communication tools eventually shape the law. And we've talked about what that looks like. Yeah. All right. Other topics in the course, other predictions just to wrap up with. Creativity will become more important than property. The magic circle is untenable because it is structuralist, if you look at it. And because, as those of you who took part in the Oculus Rift experiment will attest, as we get more immersed in the world, as gaming becomes, as we game in the world and as we bring the world into gaming, the magic circle makes less and less sense. I'm determined to have technological problems today. All right. Question, why don't we tailor our rights in terms of how we deal with the rights of others? That's something I think we're going to see. And if you agree that how we are conscious and how we game are aligned, then the law itself needs to align with our consciousness, in our video game designs, and through our community interactions, which leads us back to everything is a video game. And that's really the takeaway. So if everything's a video game, we can analyze the law from the perspective that games are actually important because they are the far edge of where the rest of our world is going to come to. And that's really the original premise of the course as it's currently structured. This is a slide from the first talk, and I hope that these have been met. These are the goals of the class: engagement, creating perspective, appreciating the legal complexity of video games, and just a very sincere thank you. You've been an amazing class. We've actually done some very cool things that have really surprised me, and it's really a testament to you guys and all your contributions. So thank you very much, and we'll get Jazz in here very shortly. Stay in touch.